Hello everyone, good evening. Can we all hear me?
Good evening, sir. I can hear you.
All right, good evening. Thank you all for joining. Welcome to class. I noticed that it seems we have a lot of people's note takers on call and not them actually present. Right, please, we want to have as many people joining for the class as possible. So please, for the mentees, let's try and reach out to our co-mentees, especially for those who will be participating in the presentation in today's class. Please, let's try and reach out to them as we start this session. All right, so please let's do that as quick as possible. Right, so while we are doing that, I officially want to welcome all of us to class. Thank you all for joining. Welcome to week 5 of the JIIPCC Mentorship and Internship program. We'll be starting class right about now. Today is technically the last class we'll be having. Today is technically the last class we'll be having in the Today is technically the last class we'll be having in the ADR class. So it will be really nice if we are all on board so that we can all participate in the simulation. So in today's class, we'll be taking our second simulation but this time instead of for mediation, we'll be taking for arbitration, right? And we hope that both groups are ready for their simulation so that we can commence. Right. I want to welcome all mentors that have joined in. Thank you so much, Mr. Nacham. I can see that you're already on the call. Thank you so much, sir, for joining. We are happy to have you on board. Thank you so much also, Mr. Babajide. I can see you are also here. We are happy to have you with us. So for the mentees, we expect to receive the simulation of Group 1 and Group 2. So please we want to start with Group 1. If the members and participants of Group 1 are ready, just like the way we did in the last session, we want to use that same format in today's class. So please, for those who will be participating in the arbitration simulation, you can kindly turn on your videos, identify yourself, the main arbitrator, and all the counsels and parties that will be involved, right? So if we can have that, we'll be taking that as soon as possible so that we don't waste time and we have enough time to discuss with the mentors and they can share their thoughts with us. Um, they can share their thoughts with us after we are done with our simulation. So, Group 1, if you're ready, please, we're also ready for you, right? I hope we are all on board. That's for those who will be participating in the simulation. I hope we are all on board, right? So let's get straight into the business of today. Group 1, please, over to you. We would like to receive your simulation now. You have 20 minutes for your simulation. Let's do that as quick as possible. Okay, I can see Mr. Ashimi. All right. Please, are the rest of the members of your group available? That is for those that will be participating in the simulation.
Yes, sir. Good evening,
Yes,
sir. They are here with us.
You said?
They are here with us, sir. Good evening, sir.
All right, good evening. So please, if you guys are complete, let's try and get it underway, right? Let everyone, as much as you can, just turn on your video so that we can quickly do that. All right, thank you. Let's get that done. Okay, who will be the main arbitrator for the class? Who is supposed to be the main arbitrator for the class?
Group leader, please, who is the arbitrator? I don't know her name yet.
Okay, if your group is finding it difficult settling in, right? Please, while you people are trying to put yourself together, we do not want to waste time, right? So if group two is ready instead, we can start with group two and then subsequently go back to group one when they are ready, right? That is if group one is not ready. Let's take group two's presentation simulation. Group two members, please let's turn on our videos and let's start as quick as possible. Are the participants of group two in class today?
Yes, sir, we are. Good evening, sir. I am
All right,
basically. I don't know.
all right. Please, if we have all the members for group two in class that are supposed to participate in the simulation, please let's get on board.
Sorry, the
Okay.
arbitrator for group one is here.
Okay,
I'm starting now.
okay. You people want to start instead. All right. So please let's go back to group one. Since you guys are ready, let's get straight to the business of things.
Thank you, sir.
All right.
Good
Please,
good evening, everyone. Today's case is no sorry. This arbitration is conducted pursuant to the Arbitration and Mediation Act 2023. My name is Grace Adesina Enyola, and I have been appointed as the sole arbitrator in this matter between Mr. Musa, the claimant, and A&B Company Kaduna, the respondent. This tribunal shall ensure equal treatment of the parties and full opportunity to present their case in line with Section 19 of the Act. May the counsels kindly introduce themselves and their clients for the record. Counsel for the claimants, please introduce yourself and your client.
All right, thank you very much, Mr. Arbitrator. I am Hashim Salwani, ICMC, and I am the counsel representing Mr. Musa in this instance proceeding.
Thank you. Counsel for the respondent, please introduce yourself and your client.
Thank you very much, Ms. Arbitrator. My name is Jason Peter. I am the legal representative and counsel for A&B Company in this matter.
Thank you. Pursuant to Section 20 of the Arbitration and Mediation Act 2023, the language of these proceedings shall be English. All submissions, testimonies, and the final awards will be delivered in English. Before we proceed, the following rules will apply. Respectful conduct by all parties. Firstly, respectful conduct by all parties. Secondly, only one person may speak at a time and only address all remarks to the tribunal. Thirdly, evidence shall be presented in accordance with sections 33 and 34 of the Act. Fourth, cross-examination shall be limited to relevant matters. Fifth, confidentiality is preserved under section 69 of the Act. And last, my final award shall be binding under section 57 of the Act. If there are no objections, we shall proceed. Counsel for the claimant, you may now present your statement, your point of claim under section 31 of the Act.
All right, thank you very much, Mr. Arbitrator. Firstly, I would like to once again appreciate Mr. Arbitrator for laying out the ground rules so perfectly and also helping us throughout this arbitration proceeding. Also, I would like to thank A&B Company for taking their time out of the busy schedule to be a part of this arbitration proceeding and also showing that they are now ready to cooperate with us. They are now ready to cooperate with us in spite of the initial mediation proceeding we had earlier, which proved futile at the end of the day. So one main thing I would like to make mention of is that this dispute has gone out of hand, and we won't want a bad blood to be created throughout this uh, session and post this talk through it and also find a fruitful and mutually acceptable solution for both parties, which we believe will also help subsist the current employment relationship between our client, Mr. Musa, and the respondent company. So, uh, going on the point of claim, so the claimant adopts the earlier tender statement point of claim, which establishes the issue in dispute before this honorable tribunal, and uh, the claimant the claimants have suffered severe financial hardship, loss of income, and as well as emotional distress as a direct consequence of the respondent's breach of the employment contract and also failure to provide remote means of working during the lockdown that was declared by the state government of Kaduna State, and which later affected the entire nation on its own as well. Also, so in essence, the claimant claims against the respondent a payment of the with 8 months withheld salaries, and as well as a 20 million naira damages for all the injuries suffered by the claimants during this lockdown period. So lastly, my client, Mr. Musa, has a very strong case against the respondent's company, and we do not believe taking this much further into the arbitration proceeding is in the respondent company's best interest, or at least we can adjust the fair compensation because my client seeks to claim before this honorable tribunal. As long as you can honor my client 8 months without salaries and as well as the fair damages of 20 million naira claimed, we can end this year now. Thank you very much.
Thank you, Counsel. Counsel for the respondent, you may now present your point of defense under Section 32 of the Act.
Thank you very much, Ms. Arbitrator. Thank you very much to the party and counsel on the other side, Mr. Ashimi, the representative of Mr. Musa. I remain Jason Peter, representative of A and B Company. So simply, we would just respectfully submit that the claimant, Mr. Musa, really has no valid claim against our company, A and B Company. As we'll be leading evidence to show, as well as relying on the absence of evidence to also prove, yes, we consider the fact that he was offered employment in our company, but the reality of it, as we'll be relying on evidence and the lack thereof to show, is that he never actually commenced work. Yes, the company also, in addition, was shut down due to the COVID-19 lockdown, which was the force majeure, and therefore no services were rendered. Therefore, in light of this, we would be submitting that no salary or damages are accruable or owed to the claimant in this matter. Yes, I would also further reserve the right to respond further to anything that the claimant or his counsel has to say in pursuance of this matter. And that would conclude my opening statements. Thank you very much.
Thank you, Counsel. Having noted the pleadings, we shall now proceed to the evidence stage provided in Section 33 and 34 of the Act. Counsel for the claimant, identify and tell the documents you intend to rely upon.
All right, thank you very much, Ms. Arbitrator. So for the purpose of this arbitration proceeding, we'll be tendering 4 documents as exhibits. The first one being, so as to that will substantiate our claim. So the first one being Mr. Musa's appointment letter. The second and the third being the recorded phone conversation between the general manager and Mr. Musa, and lastly the lockdown directive made by the states government of Kaduna. That will be all. That will be all, Mr. Arbitrator.
Thank you, counsel for the claimant. These documents are dated and marked as claimant's exhibit C1 to C4. Please move the document. If the documents are not ready, then we shall move on. Counsel for the respondents, please identify and tender the documents you intend to rely upon.
Thank you very much, Ms. Arbitrator. I remain Jason Peter, representing company A and B in this matter. So for the, in this case, we'll be relying on just two documents. Yes, the first being the contract of engagement between A and B company and Mr. Musa. We'll be relying specifically on the no work, no pay clause that is contained therein. That will be the first document. Then the second will be the notification letter by Ms. Adama, our human resource manager, to Mr. Musa in consideration of the fact that, as a notification rather of the fact that on account that he has not worked, he doesn't deserve a pay. So these would be the two documents that the respondent will be relying on in this matter. Thank you very much.
Thank you. Documents are now updated and marked as respondent exhibits R1 and R2. Having claims and the evidence, the tribunal will proceed directly to the examination of the parties' witnesses. Each witness will be cross-examined by opposing counsel, and the tribunal may also ask clarifying questions. Counsel for the respondent, you may proceed with your cross-examination of the claimant.
Okay, thank you very much, Ms. Mediator. Sorry about that. Thank you very much, Ms. Arbitrator. May I confirm that the claimant is here with us? Mr. Musa, are you here?
Yes, I'm here. I'm representing Mr. Musa in this arbitration.
Okay, thank you very much. Okay, so I would comfortably refer to you as Mr. Musa. So, first of all, we heard that the arbitrator had stated that questions would only be limited to important matters. So let me go straight to the point. Mr. Musa, were you at any point offered a job appointment with our company, A&B company? Yes or no?
Yes, I was. I was
Okay,
offered.
Mr. Musa. Yeah, thank you very much for this. In the interest of time, I would prefer you restrict your answers to yes or no. Okay, thank you very much. Okay, so I believe you are a learned individual, yes, and you have track record to show all of that. So I can ask that you signed the contract of engagement freely, didn't you? Yes or no?
Yes.
Okay, and in light of that, it is known that you thoroughly read through this document. So my next question would be, does the contract of engagement state at any clause that you are entitled to payments from our company without work? Yes or no?
No.
Thank you very much. May the record show that he has admitted that the company policy, the no work, no pay policy in the company is binding on him, and he was quite informed about this. So I would like to reestablish at this point that there is no evidence in this matter. We just heard the your representative, the claimant representative, tender evidence, and there is no document that he has tendered to the effect that you work with our company, not even for one day. Yes. So my next question to you, Mr. Musa, would be, you claim to have put a call through to the general manager, right? Mr. Musa, you realize that this is a company and we are not one of your relatives, right? So my question to you is, why didn't you, in reaching out to the general manager in respect of your employment, why didn't you go through the formal means of sending an email or sending letters to the appropriate department? Why did you have to use a phone call?
Okay, thank you for that question. So basically, the main reason why I resorted to placing a call to the general manager was to ensure swift response. I wanted to get swift response because I wasn't really sure that if I had sent an email, it would be replied immediately or something. And I was eager to start work. So basically, this is just the main reason. Because if I had placed an email to the company, it might have taken weeks or months to get a reply. So basically, that's just it.
Okay, thank you very much, Mr. Musa. You are stating before Mr. Arbitrator and everyone here present that you made a baseless assumption about our company that has been operating for well over 2 decades, saying that you thought that we wouldn't respond timeously, and because of that, you went through a phone call. Well, that is going to be left for the arbitrator to use in consideration of your case. Moving on, my next question and my final question to you would be, you claim to be very willing to work, Mr. Musa. Why did you not make another attempt to reach out to the general manager when you got no response to the human resource department? Yes, when you got no response from our HR department, that is, you've shown an interest in really working with us, but yet the facts in this matter show that you waited 8 long months, which by my calculations is it's a great majority of a year. So why? What was your reason for the acquiescence of time?
Okay. So specifically, I was told to await a call from the HR manager. This is to show you that it is not the general manager's position to assign tasks or work to me. So I was specifically assigned to wait to get a response from the HR manager. She was to direct me on how I would work remotely. And so it's not the duty of the general manager to assign any task to me.
Thank you very much for your response. However, I must point out that to a reasonable man, that response is not sufficient to explain why you would wait 8 months. We understand if you had waited 1 month, highest 2 months, at the very max 3 months before reaching out. But you stayed home, you were comfortable, you waited for so long a time. And may I state here that in law generally, all right, and in the consideration that this tribunal would give to this matter, we are aware that equity aids the vigilant and not the indolent, yes, and not those who sit back and wait for things to happen, right? So I believe your decision to keep mute for 8 months defeats your claim of willingness to work. Well, in the interest of time, that would be my last comments and question for you, and that would conclude the cross-examination of this witness. Thank you very much, Ms. Mediator, and everyone here present.
Thank you, counsel. The witness is excused. And thank you, counsel. The witness is excused. Counsel for the claimant, you may now cross-examine the respondent witness.
All right, thank you, arbitrator. I'll be proceeding with that now. Miss Adama, right?
Yes, I am Miss Adama.
All right. If you are the current HR manager of A&B company who processed Mr. Musa's employment, am I correct? I hope you heard my question with clarity.
Yes, and I answered.
All right.
I did.
All right. And after the function, you went with him to a hotel, and I believe something came up there.
I cannot hear you very well.
I'm asking, after the final documentation of the employment contract, you went with him to a hotel, and I believe something came up there.
Yes.
All right. He tried to. I also believe, if I am correct, you made move to have a continual relationship with him after what transpired between my clients and between you and my clients in the hotel, and you were upset about his response, and at the end you told him you would make his life miserable at work. Am I correct?
Well, that was in a fit of anger. So all of that ended there after I made the statements to Mr. Musa.
I believe this is a yes or no question. Is it yes or no? My question is straightforward.
Well, that happened.
What is your response, please?
Yes.
All right. And as the HR manager of A&B company, who I presume to be very diligent at work, although that presumption might be proved wrong through your testimony, your job is to reach out to all the employees in the company, working with the company, and also help them on how to deal with work regularly. Yes or no?
Well, that will not be a yes or no question to me, Mr. Lawyer, because I am to express the nature of my job, right?
I am not asking you the nature of your job. You know that's right. So, because
am I correct?
I'm putting to you a question which I believe you just give me direct answer without any further explanation. We don't have all this.
That will not establish the nature of my job.
All right. What I was asking is that you ought to, like, you as part of your job as the HR manager of the company, one of your duties is to reach out to employees working with the company and deal with them on how to go about their respective works. Because I believe they also came into the company through you.
Well, my job is to make provisions for employers who are in need, basically.
That's cool.
Employers who are very listed on our payroll.
Who are very listed on your payroll. Thank you very much.
Yes.
And if the employees of the company are the ones listed on your payroll.
What did you say?
And I believe the employees of the company are those listed on your payroll, not employees. What I'm saying is that I believe the employees of A&B company are those listed on your payroll and not employees of B and K company, Abuja.
You see, the thing is, Mr. Musa was only offered a letter of appointment and he had not started to work with us. So there is,
please,
as good as there be no evidence to show that he worked with us.
Miss Adama, my question was straightforward. The question is, employees of A&B company are those A&B company Kaduna are those expected to be on the payroll and not employees of B and K company Abuja.
B and K company, I do not know anything about that.
All right. Employees of B and K A and B
company.
are expected to be on the payroll.
Yes.
All right, thank you very much. So during the lockdown, I believe because you have an altercation, let me just use the word altercation with my client, Mr. Musa, you decided it was a personal decision not to give him the directives on how he will do his work during that lockdown period.
No.
Are you saying it is now the company's policy not to reach out to employees and guide them on how to work from home?
I am simply saying that Mr. Musa never made it known that he was even willing to work at all.
But he's an employee of the company. Thank you very much. You've answered that already. Don't stress yourself. It's for the explanation. So your refusal to call him was not a mistake. It was revenge, wasn't it?
I was not supposed to call Mr. Musa.
You were not supposed to call Mr. Musa.
A lot of employees, and you do not expect that we begin to put a call through to about like 200 of workers. The rule is simple. Ask and it shall be given unto you.
Your explanation is enough. Thank you very much. All right, Mr. Arbitrator, that will be all. And I believe all the responses of the witness are duly noted by the arbitrator. Thank you very much.
Thank you, counsel. The witness is excused and the cross-examination phase is now concluded. We shall now hear the closing submissions. Counsel for the claimant shall proceed first, followed by the counsel for the respondent. Counsel for the claimant, please proceed with your closing submissions. Counsel for the claimant.
Yes, I'm with Ms. Arbitrator. Thank you very much, Ms. Arbitrator. I want this honorable tribunal to put into consideration the fact that the claimant who has suffered a lot of injuries during this lockdown period as a result of the company's negligence through its HR manager is a family man, and the fact that he couldn't get his withheld salaries affected his responsibility as the husband and the breadwinner of his family, putting into consideration the fact that he had earlier resigned from a job that paid him 200,000 naira. And also, we want this honorable tribunal to ensure that this matter is settled judiciously in the best interest of our clients. And on that basis, I would like to appreciate the members of this honorable tribunal, starting from Ms. Arbitrator for being part of this arbitration proceeding, and also for being for giving us a helping hand, and also the council, the other party for also giving their open hand to have this dispute settled amicably between ourselves. And at the end of the day, we believe the dispute will have a fruitful and mutually acceptable solution, and also the current relationship between our clients and the respondent company will keep subsisting to the end of the day. Thank you very much, everyone.
Thank you, counsel. Counsel for the respondents, please proceed with your closing statements.
Yeah, thank you very much, Ms. Arbitrator. Let me also extend my appreciation to the counsel on the other side. So, in conclusion, having cross-examined the witness and tendered the evidence before this honorable tribunal, we are simply submitting that Mr. Musa never physically or remotely commenced to work. there has been a lack of evidence by the claimant to show anything that shows that Mr. Musa actually worked with us. Yes, he got the contract of employment, but he did not work with us. Okay, so he's not entitled to any compensation whatsoever. And as we had stated earlier, there was a force majeure, the COVID-19 lockdown. During this period of time, a lot of things happened. There were so many shifts, so many changes, and much of the work was remote. But Mr. Musa, both on site and online, did not really work with us. And so he's not entitled to compensation. In addition, there was no breach of contract. There was no requirement on our part to pay Mr. Musa any form of compensation whatsoever. Okay. And then finally, we are also relying on the fact that the claim for 20 million naira damages is by the claimant is excessive and unsubstantiated. Okay, Mr. Musa has not presented any evidence of any actual damage suffered, and this tribunal won't go around spilling damages everywhere for random reasons. Okay, so there has not been any evidence to show that Mr. Musa actually suffered damages, substantial damages. There's no receipt, there is no payment whatsoever that he made that would warrant this tribunal providing him with that award in alignment with what he has asked for. So in conclusion, Mr. Musa's claim lacks merit. He was never onboarded, he never worked, and the company was more or less shut down due to a national emergency. His claim for the salary is legally and factually baseless. And in light of this, we respectfully request that the arbitrator dismiss the claim in its entirety. At this point, let me once again appreciate the arbitrator and everyone here present for their time and cooperation in this matter. Thank you very much.
Thank you, counsel. I'm going to share my screen and share the arbitral award and read it out. Sorry. Okay. I hope everyone can see it. Having carefully considered the pleadings, the documentary evidence, the cross-examinations, and the submissions of the counsel, the tribunal finds that a valid contract existed between the claimant and the respondent. B, the respondent failed to remote work or oral communication to the claimant. And C, how the claimant rendered no service and lockdown constituted an extraordinary circumstance beyond the respondent's control. Accordingly, the tribunal awards the claimant compensation equivalent to 3 months' salary. The claim for 2 million naira damages is dismissed. This constitutes final and binding award of the tribunal under Section 57 of the Arbitration and Mediation Act 2023. The proceedings are hereby. Thank you. Thank you, I'm done.
All right, thank you very much. Thank you very much, arbitrator, and to everyone who participated in the mediation for Group 1. Well done to you all for such a wonderful arbitration simulation. So we will be going to Group 2. We hope the members of Group 2 are ready for their simulation also. Please, let's do well to, just like the way Group 1 went straight to it, let's get straight to your simulation. Group 2 members, if you are with us, please, we are ready for you. Can we have members of group 2 on call? Where are the arbitrators? Where's the arbitrator and the counsels?
The arbitrator is here.
All right, please go ahead and let all members of your team introduce themselves.
Okay. My name is Chiamaka, and I'm the arbitrator for Group 2.
My name is Omotosho Timdolua, and I am the counsel for the claimant, Mr. Musa. Thank you.
Good evening, everyone. My name is Esther Uba, counsel to the respondents A and B company. Thank you.
Okay, so my name is Chiamaka, and the arbitrator, and my decisions is legally binding on both parties as per the agreement. I have read the relevant pleadings and evidence, and hearing will be in order. This is a hearing in a matter of arbitration of a dispute between the claimant, Mr. Musa, and the defendant, the A and B company. The order of today's proceedings will be as follows. Claimants will be allowed to make their submissions, followed by the respondent. I would like to hear the argument from the claimants.
Thank you, my honorable arbitrator. I appear as the counsel for the claimant, Mr. Musa, who is not physically present. I will fully represent him and answer any questions on his behalf. Due to the circumstances of this matter, let me state that Mr. Musa was employed in Abuja, earning 200,000 per month. On 10th March 2020, the respondent offered him a new job at 250,000 per month with a date start of 1st April 2020. Trusting this offer, he resigned from his previous employment. He completed all required documents with the respondent and was ready to start work. Unfortunately, with the COVID-19 lockdown, the respondent failed to honor its promise. The general manager assured him he would be contacted for remote work, but that never happened. From April to November 2020, my client received no salary, no communication, and no support, leaving him and his family in severe hardship. My client is therefore entitled to salary arrears and the sum of 20 million naira in damages for the following reasons. Firstly, reliance on the respondent's promise. He resigned from his previous job and left a stable income because the respondent promised him a position. This is supported by his resignation letter, the employment offer letter, and the signed employment contract in Exhibit A, B, and C. Secondly, readiness to work. The respondent may argue the lockdown prevented him from starting, but he sent follow-up emails and messages asking for instructions and remote work. The respondent never replied, proving that my client was ready and willing, but the company failed to act. Thirdly, the role of the HR manager. My client had explained that the human resource manager, Mrs. Adama, had a personal relationship with him in the past, which he ended. Because he is married with children and committed to his family, he believes that in retaliation, Mrs. Adam deliberately refused to reach out or facilitate his resumption, choosing instead to neglect his situation. While this is a sensitive matter, It shows that the respondent, through its officer, acted in bad faith and failed in his duty to communicate and honor the employment agreement. Next, he received no salary during this period, had shown by bank statement and had expenses for his family, proven by receipts. The sum of 20 million naira is a fair compensation for the hardship and emotional distress he endured. Also, the respondent had a duty to communicate, provide alternative arrangement, or at least clarify the situation. Their silence coupled with personal bias caused avoidable hardship. My honorable arbitrator, I thank you both for your patience and attention throughout this matter. It is clear that my client, Mr. Musa, acted in good faith, relying on the respondent's promise, but was left stranded, without income and without communication during the most difficult period of the lockdown. He lost his livelihood through no fault of his own, and he suffered financial and emotional hardship that no hardworking family man should endure. In the interest of fairness and justice, I respectfully urge you, my honorable arbitrator, to find in favor of my claimant to award his salary arrears and to grant the sum of 20 million naira as just compensation for the hardship suffered. I thank you sincerely and I humbly pray for a favorable judgment. Thank you.
The respondent, you may state your case.
Thank you, Honorable Arbitrator. Good day, Honorable Arbitrator and my learned colleague. I remain Esther Uba, the counsel to the respondents A and B company. I will swiftly move to the brief facts of this issue in arbitration. Honorable Arbitrator, the facts of this matter are largely undisputed. The claimant, Mr. Musa, applied to work with A and B company in Kaduna and was offered employment to resume on April 1st, 2020. However, before the resumption date, the Kaduna state government imposed a COVID-19 lockdown, which affected all business operations. I repeat, all business operations. Consequently, the claimant did not resume work, did not perform any service for our company, and was not placed on the company's payroll. And yet, he demands salary of 8 months and 20 million naira as damages. The respondent, A and B company, strongly and vehemently opposes this claim. Honorable Arbitrator, are issues for determination. The respondent respectfully submits the following issues which calls for determination. 1. If the respondent will be held liable for the events caused by the COVID-19 lockdown. And secondly, if the claimant, having not resumed work, is entitled to damages or salary. I will move straight into our arguments for this arbitration. Honorable Arbitrator, the respondents A and B company respectfully submit that the COVID-19 pandemic and the resulting lockdown were circumstances beyond the company's control, and it is very evident. And such unforeseen events are recognized in law as acts of God, which temporarily suspend contractual obligations. Honorable Arbitrator and colleague, permit me to say that this unforeseen event temporarily relieves party of their obligations and also relieves the company of its obligations. The lockdown made it impossible for business operations to continue. Hence, the respondent, my client, cannot be faulted for the claimant's inability to resume work. The company, A and B company, acted in good faith throughout. Honorable Arbitrator, permit me also to bring to your notice the case of Taylor and Cardwell, 1863, where it was clearly established that parties are relieved from a contract when the object upon which the are relieved from a contract when the object upon which it depends is destroyed, creating a condition of impossibility for its performance. Honorable arbitrator, this case laid a principle that when performance becomes impossible due to unforeseen circumstances, parties are discharged from obligations. Accordingly, the respondents A and B company cannot be held liable for the claimant's inability to resume work due to duties occasioned by the lockdown. Secondly, it is a settled principle in law, and you all will agree with me, that salary is earned in exchange for work done. It is simple, Honorable Arbitrator. No work, no pay. The claimant, Mr. Musa, admittedly did not resume work, and he did not render any service to the company. Therefore, he cannot lawfully demand payment for work which he never did. The maxim quid pro quo applies in this matter, which simply means one cannot reap where he did not sow. And also, in labor relations, you will agree with me that the rule is clearly established: no work, no pay. Furthermore, Honorable Tribunal, it is right that I mention that salary is a consideration for services rendered. The principle of no work, no pay strictly applies in this matter. Permit me also, once again, Honorable Arbitrator, to bring to your attention the case of Chukwuma and Shell Petroleum Development Company, a 1993 case, where the apex court of our land emphasized that salary is earned through performance of duty. It will interest you to know, my learned friend, that the case of Chukwuma and Shell Petroleum Development Company is quite familiar with this current case, but the Supreme Court gave its judgment in favor of the respondent. In the light of this decision, Honorable Arbitrator, the claimant's failure to resume, regardless of the reasons, disentitles him from any salary claims. And my learned colleague made mention of the relationship that existed between Mr. Musa and Miss Adama. But permit me to say that the relationship that existed between them are personal and are unsupported by credible evidence. And even if it is proven, such actions were not within the scope of her employment and cannot bind the company. The law is not ambiguous, Honorable Arbitrator. An employer is not vicariously liable for the personal or malicious acts of an employee committed outside the course of his employment. Honorable Arbitrator, let us not be quick to forget the case of Nigerian Airways Limited and Makinde, where it was held that an employer cannot be held liable or responsible for acts done outside the authority or duty of an employee. In conclusion, Honorable Arbitrator, the respondent submits that the lockdown was an act of God, which excuses performance, which include reaching out to Mr. Musa. And secondly, the claimant never resumed work and therefore no salary was earned. Accordingly, Honorable Arbitrator, counsel to the respondent submit respectfully and praise this honorable tribunal to 1. Dismiss the claimant's claim in its entirety, and secondly, award cost in favor of the respondent for this needless arbitration. Lastly, I thank this honorable arbitrator for your patience and consideration. Counsel to the respondent so submits and rests his case.
Claimant, do you have any response to what the respondent has said?
Thank you, my honorable arbitrator, for the opportunity given to appear before the tribunal again. My honorable arbitrator, the respondent may argue that the client cannot be paid because he did not actually work. With respect, that argument fails. The law is clear that when an employee is ready and willing and able to work, but is prevented by the employee is still entitled to wages. Section 17 of the Labour Act places the duty on the employer to provide work when the worker is fit and ready. The court held in Springbank versus Babantide that salary is payable if the worker is prevented by the employer. Secondly, the respondent may also argue that the company is not vicariously liable for the HR manager, Mrs. Adama, because her actions were personal. With respect, that argument is misplaced. The law on vicarious liability distinguishes between a frolic of one's own and a detour. If an employee abandons the employer's business entirely for personal matters, that is a frolic, and the employer may escape liability. But where the employee actions are still tied to official rule, even if influenced by personal motive, that is a detour, and the employer remains liable. In this case, Mrs. Adama's duty as HR manager was to facilitate communication and resumption, even if her personal feelings influenced her. She was still performing her official role. At worst, that was a detour, not a frolic. The company therefore remains liable. In a similar case of NNPC versus Aladbanju, it was affirmed that once the act is linked to the employer's business, liability follows. Also, the respondent may also argue that the COVID-19 lockdown excused their failure to employ my client. With respect, that argument doesn't hold. The lockdown did not remove the company's duty of communication. The respondent assured my client that he will be contacted for remote work, but no such communication ever came. For good 8 months, Honorable Arbitrator, good 8 months, he sent emails and messages seeking guidance. However, the company stayed silent. Section 7 of the Labour Act requires employers to provide clear terms of employment in writing and maintain communication of this obligation, in which the company A or B failed. The duty of good faith in employment requires an employer to update employees on major disruptions instead of leaving them in limbo. The respondent's silence, coupled with the HR manager feelings, worsened my client's hardship and is a breach of duty. My honorable arbitrator, having carefully presented this argument, I respectfully submit that my client, Mr. Musa, was ready and willing to work, but was unfairly prevented by the respondent. In the interest of fairness and justice, I humbly urge this tribunal to hold the respondent liable and to award my client his salary arrears and to grant the sum of 20 million naira as damages for the hardship he endured. I sincerely thank you, my honorable arbitrator, for your patient attention and consideration towards my case. I rest my case as the counsel of the claimant. Thank you, honorable arbitrator.
And the respondent.
Thank you, Honorable Arbitrator, for this opportunity yet again to speak on behalf of my clients, A and B Company. I have just a few things to say to counter what the counsel to the claimant has mentioned. Now, concerning the issue of a personal relationship between Mr. Musa and Ms. Adama, I still want to vehemently stand on my ground, stating that the relationship and whatever affair that existed between Mr. Musa and Ms. Adama is a personal one and does not, in fact, have anything to do within the scope of her employment. So, whatever relationship that existed between them or whatever affair they had does not affect the HR reaching out to Mr. Musa. And secondly, I also want to make mention of the fact that the claimant, Mr. Musa, said he reached out to general manager, stating that asking when he was to resume work, and the general manager told him that the HR will reach out to him. I would like to bring to your notice, Honorable Arbitrator, that the reason why Mr. Musa was not reached out to or was not um, communicated or contacted as to when to begin his remote job, that was because after the conversation between the general manager and Mr. Musa that he will be reached out to for work remotely, the company shut down its business, and that involved reaching out to employee, whether via SMS or emails. So during those 8 months period, while Mr. Musa sat at home hoping that the company would reach out to him, the company was not undergoing any business operation. There was no business activities in the company, which also include responding to emails and reaching out to employees. So Mr. Musa should not hold on to the fact that they had an existing relationship that hindered the HR from reaching out to him. The company was not undergoing any business operations, and so they could not reach out to the claimant. Thank you.
Having heard both of you and your pleadings being submitted to me and your evidences, I've also seen the evidence showing the messages that have been exchanged between the claimant and the defendant. But however, the claimant was the only person who sent messages saying that he is married and doesn't want to continue any relationship with the employee of the respondent. And then for the contract, going through the employment contract before me, I can see that there was not an act of God clause included in the employment contract. There was not an act of God clause included in the employment contract. Therefore, going forward, I'm going to read my arbitral award. In the matter of an arbitration between Mr. Musa and A and B Company, this dispute arises from a contract between Mr. Musa and A and B Company for breach of employment contract and a violation, which is a violation of the labor laws in Nigeria, Labor Act. The parties agree to resolve any dispute through arbitration. The dispute concerns non-payment of the 8-month salaries, whereby the claimant wants 20 million naira as damages. The claimant claims that the respondent failed to pay him his salary, which has made it difficult to run his day-to-day activities. The respondent argues that the principle of no work, no pay applies to this case, and that the claimant does not have any entitlement to the damages or salaries. The respondent also states the act of God. Now, after reviewing the evidence, including witness testimony and documentation, I found that although the pandemic was an act of God, it was not included in the employment contract. Also, there was no evidence showing that Mr. Musa was frustrated by the relationship or the affair he had with Ms. Adana. My decision is that 1, the respondent is liable for the damages incurred by the claimant, and the respondent shall pay the claimant the sum of 5 million naira in compensation. This award is final and binding. Both parties are expected to comply with the terms outlined above.
Thank you, my Honorable Arbitrator. As the
Thank
tribunal
you,
speaks.
Honorable Arbitrator. May this tribunal be pleased. Thank you.
All right, if I'm not mistaken, you guys have come to the end of your arbitration session, right?
Yes, sir, we have.
All right, thank you very much. Well done to Amaka, Motosho, and Esther. Thank you so much for putting up a wonderful presentation of your arbitration simulation. Well done to you and to every member of the team that participated in the discussion and ensuring that your group is able to make your simulation in class. So well done to you guys once again. So we'll be going back to the mentors. We'll be handing over directly to them for their comments on your simulation and anything they would like to add in relation to the work you have done. So Mr. Nacham, if you are with us on call, I would want to hand over back to you. Hello, Mr. Nacham.
All right, good morning, good afternoon, good evening, from wherever you are joining us from.
All right.
Let me first start by appreciating all the benches for putting their time and resources together and making these presentations. It has been interesting watching and listening all the way to this point. So, well, I'll commend them for their efforts and what they have done. The time is too short for us to have something more than this. So thank you so much.
Mr. Nacham, are you done? Sorry.
Hello, hear me?
Yeah, I can hear you. Sorry, you were gone for a bit.
We will start the comment from the mentors. I saw that, I don't know, Mr. Isaac, is he around? I can see Bara.
I'm here. I'm here. Can you hear me?
Yes, please go ahead.
Okay, thank you. Good evening, everyone. I hope everyone is doing well. And let me commend all of you for a good job done. You have done well when it comes to conducting arbitration simulation. Although there is more work to be done on this matter, but the little that you're able to do is commendable. So let me commend you for that. All right. I want you to take notice that I don't know maybe whether the simulation should have included that maybe you conduct arbitration management conference or pre-hearing meetings so that before you come to the meeting, you have agreed on the matters that you are going to discuss or going to discuss. So you agree on that during the pre-hearing meetings. Exhibits, how to mark your exhibit and everything. Those things are determined at the early stages when you are submitting, because when you do your pre-hearing meetings, you agree on when to submit your statement of claim and also statement of defense. During that time, you agreed on how the exhibit will be numbered or will be marked so that it will differentiate between the exhibit. So all those things will be agreed upon before you come for the hearing. So if you are doing the hearing, it's about when they come, the arbitrator welcomes them and also make reference to the meeting that happened earlier, which is the pre-arbitration meeting or the meeting that happened before the actual hearing date. Based on that, and make reference to the timetable that the parties have agreed upon, and at the same time also make reference to the rules that will govern the process. So because you have agreed, you might have agreed on the rules. The law is there, which is the AMA 2023. But the rules that will govern the process, the parties must agree on the rules. Which rule? So when it comes to the submission of a statement of claim, the submission of statement of defense, the duration that the parties are going to give to themselves to open their case, and also the responses. Are they going to bring witnesses, or are they going to use witness statements? All these things would have been agreed upon. So when you come for the arbitration, you just go straight. So the arbitrator will welcome the parties. The parties will now introduce themselves. So you allow them to introduce themselves and who they are representing and who is representing what. After that, you now you can refer to the rules that you have agreed upon. Then they open their defense. If you are opening your defense, opening your case, so you allow them to open their cases. So party A will open their case and talk about their case and what it is and everything. Then the other party also open their case. You move to a stage if there is a need for witnesses, where they will call their witnesses to talk, and also cross-examination will take place. Once all these things are done, then the arbitrator work is now complete. The arbitrator will now go and evaluate the evidences that has been presented to them and all the matters, all that happened, and so that he evaluates and come out with an award. The arbitrator can also ask clarifying questions. So it is not like the arbitrator will just sit there and be asking them to be talking. No, you can, if you think that there are certain things that you don't understand or there are issues that you have to clarify, the arbitrator can ask clarifying questions to clarify the issue, to get better understanding so that you know. And again, when it comes to matters of employment contracts and issues with employment, and when it comes to arbitration, the arbitrator must also look at, because if you had maybe pre-hearing meeting, and one of the principles of arbitration that you could have agreed upon is, we call it amiable compositor, which means that not only is the arbitrator bound to use the facts and evidences, but to also use equity and also fairness. So if it must be fair, because if you are talking about on the side of each of the parties, you might have hired somebody and you promise that you give the person a remote work to do. The person has been staying home waiting for the remote work, which did not come. So even if the person did not work, definitely the person was appointed, and for that, the moment you give somebody an appointment letter, the person has become an employee of your company. So once the person has become an employee, in fairness, what were you supposed to do? Somebody made mention that, oh, we shut down, we couldn't continue with our operation, but was it communicated to him that, oh, we have shut down, we are unable to work now, so in lieu of maybe appointing you and not able to give you work, we are extending this hand to you. Take this as a compensation so that you can look for other alternative work. That was not done. So in fairness, if you are bringing not even law, but in fairness, you have not been fair to the person. So you evaluate all these things. So in fairness, you bring all these principles to bear and make sure that you give an award that fits the issue, not only about law. If you are talking about only about law, you may use a lot of technicalities and say that maybe the person does not deserve anything. But if you look in fairness, you realize that the person must be able to get something out of maybe what is happening. So, in all, let me commend all of you for a good job done, and I wish you the very best. Keep it up and build upon this success. There are a lot of arbitration articles online, arbitration materials online. Please read them, evaluate what you've done, reflect on what you have done, what you have witnessed today, and build upon that. Based on that, you can become one of the best arbitrators. And I wish you the very best. Thank you. Nanchan, this is all that I have to say for now.
All right, thank you very much, Mr. Isaac, for that contribution. Okay, so um I can see Adams, I can see Baratu. Any of you can go on.
All right, good evening to the coordinator, and good evening to the mentees and all the mentors here present. I would like to begin by commending the mentees for the work they put together, beginning from the group 1 and then the group 2 in terms of simulation for the arbitration. I observed some things in the presentation and I want to just bring them to bear. First of all, in group 1, I want to commend their arbitrator and also all those who did the presentation for the industry they put on. However, arbitration is a formal proceeding, so even in the simulation, there is an expectation of being formal in terms of dressing. I think I noticed in group 1, even though group 2, I didn't see any of those presenters, but in group 1, I noticed the dressing of the counsels and the clients and the witnesses were all good, but the dressing of the arbitrator was not formal for the work that was presented. And I was also noting the sections. I don't know whether I was the one not getting the sections in the AMA that was quoted. And I was wondering if there is a mix-up in the sections referred to by Group 1 in the arbitration simulation. Now, coming to the award that was shared on the screen for Group 1, the award, perfect. But one of the key aspects of an arbitration award is that the reason for the decision is very, very important. I think the first mentor that spoke said something about it. You have to consider fair or not fair and some other reasons. But the reason for reaching the decision you reach has to be stated in the award. Now, I also noticed in the format of the award, the arbitration is stated to be held in a particular place, but the arbitrator's name is missing. So it is not stated before which arbitrator. And another thing I noticed in the presentations for the two groups is that in the award also, talking about group 1 and group 2, the award, apart from not stating before the arbitrator or the name of the arbitrator, it's also lacking in terms of the final part of the award. There is a signature of the sole arbitrator, but who the sole arbitrator is not indicated there. Now, moving forward, I commend also the group 2 in terms of their presentation. I noticed the person who acted in the simulation as I think Adama in group 2 was trying to be evasive, but the council was also trying to nail the fact that Mr. Musa was employed, and since he is under the payroll of the employment, he is entitled to his salary, or at least a compensation for the lockdown or for the exceptional circumstance of the lockdown. Now, for the group 2, we didn't have opportunity of hearing their point of claim and point of defense, but it was more of their final or closing submissions that we were able to have. So, like the first mentor stated, there are certain things that has to be done before leading to final award. And one of the first thing that happens in arbitration is giving the notice of the dispute. And after the notice of the dispute has been given, which is the simulation of the A and B company and Mr. Musa, the parties having selected an arbitrator will also have to confirm this arbitration. Is it an ad hoc arbitration or it is institutional? The awards are also quiet about it. Was the arbitrator appointed by an institution, or the arbitrator was appointed directly by the parties? And like our first mentor stated, Mr. Isaac, for the second group, I wouldn't say anything because we didn't hear the preliminaries leading, or even the proceedings leading to the final submission. But for the first group, we were not sure of which rules were applied in the arbitration. Was it the AMA, even though AMA sections were quoted, but then was it the AMA arbitration rules that applied, or did the parties agree on some certain rules that will apply? And in case of any lacuna, which rule will apply? So also the other part that I noted is that in order to evaluate in an award, all the parties' evidence is put into consideration. And the arbitrator also goes beyond the parties' evidence to look at the issue itself as it is. Because if you tie it to the parties' evidence, there are sometimes that parties can decide not to present certain evidence, like in the case of the A and B company trying to protect themselves from liability. So in all, I think the two groups have tried, and I commend their efforts. And it is something that cannot be done in 20 minutes. It's presenting a complete arbitration simulation. There are a lot of stages in arbitration. And also, maybe for lack of manpower, I guess, for the groups, there are supposed to be introduced to us whether there is a secretary for the arbitration tribunal, whether there are other staff who support in the arbitration in this simulation that we took today. So for now, I want to pause at this moment to say that for the first group, I noticed they tried as much as possible to bring in all the proceedings. But for the second group, they are starting from the end of the proceedings. I guess they were trying to save time. So thank you very much for this opportunity, Mr. Nanchon.
All right, so thank you very much for that wonderful contribution. That's great. So Well, I have Mr. Adams in the house. Please, Mr. Adams, please, over to you if you want to.
Good evening, everyone. I'd like to thank the entities that have spoken so far. They have mentioned a lot of attributes of arbitration. I also want to appreciate the mentors. Sorry, I mean, yeah, and I want to appreciate the mentors that have spoken as well. I want to appreciate the mentees for the work they have put into this simulation. Basically, I think maybe for time constraint, there are some parts that we did not put into it, just like the second mentor just mentioned. We're supposed to know the secretary, supposed to know. Okay, for the first group, you mentioned that only one arbitrator would oversee the arbitral proceedings. For the second group, did not mention that. There was no mention of how they got about the first, got about having just one arbitrator. The parties agreed to one arbitrator, but there was a deadlock and they didn't decide on according to Hammer, one arbitrator was appointed and whether the appointment was by parties or by the local court. So all those things were supposed to be mentioned and all throughout the name of the arbitrator. So we're supposed to know that, we're supposed to know the secretary. Then basically the rules and all that will have been put in place and mentioned because the formal setting should have been communicated to the, the parties. So the parties, including our lawyers, should be aware of this. And also, even though it's an arbitration, the parties themselves should have been able to mention claims before the arbitration should be. So, taking it from there, then they open, the case will be opened. And so, giving it to the counsel for the other side to look into the evidence of the first party. So, by and large, I would say that we tried, but would encourage them to listen and take notes, listen attentively to what the mentees have mentioned. They have covered a lot of grounds as regards the proceedings of an arbitration, and it's sacrosanct that they put this thing into practice and to try them in real life arbitration. I think once again the teams and the mentor
All right, thank you very much, Mr. Adams, for that wonderful contribution. Thank you so much for creating time and being with us. Okay, so now we have other mentors and experts who I have invited to be with us, and they are going to also make comments on what they have heard. So let me first start by calling Mr. Jeffrey, all the way from Uganda. Mr. Jeffrey, are you with us?
Hello, good evening. Yes, I hope you can hear me.
Yes, we can hear you.
So I joined at the start, so I caught a bit of the beginning and some of the first presentation. I missed out some of the middle part. So I think really what I can comment about is just the initiative. I think the research that went into this, and I appreciate what effort has been put in by the students and by the people at Settlement House. As my friend has introduced me, my name is Jeffrey Kadu. I am a lawyer. I'm an advocate in the Republic of Uganda. I am an advocate. I work with a law firm called AF Mpanga Advocates. I am also an arbitrator. I am also a mediator. I'm a member of the Chartered Institute of Arbitrators. I am on the committee, the Young Members Group of the Chartered Institute of Arbitrators in Uganda. And I also work with an organization called the Arbitration Fund for African Students that was started by Professor Emilia Onyema and Professor Crispus Nyombi. So a lot of the work that we do with the Arbitration Fund for African Students involves working with students who are in universities such as yourselves or people who are at the early stages of their career. So far, we have gone to Tanzania. We have worked with some students in Kenya. We have worked with some students in Rwanda and Ghana and the School of Law in Nairobi, Kenya, and hopefully in Nigeria someday. But I'm very glad to be here, and I'm very glad for the initiative. Maybe one time when I keep interacting with you more, I can also bring some of the people who I work with, some of the experts who are on our advisory board, like Professor Emilia or Professor Crispus Nyombi, or senior advocate Bozimo from Nigeria, or some other people who I think can be very beneficial. So maybe going forward, as I keep interacting with you, I'll also be able to come in and help and maybe train or see how I can interact with you or give you some practical cases that I have worked with and how they have ended. But I'm glad to be a part of this, and I really look forward to more interactions like this. Thank you very much.
Mr. Jeffrey. We look forward to doing more together. Thank you so much. So I have also here Miss Ian Aljak from South Sudan, but currently in the Arab, what do you call it? She is presently not in South Sudan anyway. Please, Ian, if you are with us, can you have the floor?
Yeah, good evening, everyone, and good afternoon and good morning, wherever you are. Thank you, sir, for the invitation. I'm really glad to be here, and just echoing what my colleague has just said now. It's a great initiative, and I appreciate also, let's say, the students, the mentees, the mentors who has done this, and also for the center on this initiative. It's a great initiative, and it's a good thing. It's very rare that you get such kind of practical kind of experience for as an arbitrator. Most of us have done it the hard way. Yeah. So very well done for everyone. I unfortunately, because of the let's say the change in time, I missed the first hour, but I've let's say caught up with the last part, and I have nothing to add from what the comments that has been said, and I think it's always a work in progress, and there are improvements, and I'm quite sure that for the students who are here, they would always have the benefit of the mentors that are here, that they can go always and ask and improve. So thank you very much and well done, and looking forward to much more interaction in the future.
Thank you very much. Can you tell us a little about yourself?
Okay, yeah, sure. I'm from South Sudan, as you said. I'm a practicing lawyer in South Sudan, but I'm currently working as an in-house lawyer in Abu Dhabi, which is in the United Arab Emirates, and I would say Dubai. Perhaps it will be very, very much, because not a lot of people know Abu Dhabi, which is the capital of the United Arab Emirates. So I was in private practice for a long time. I was a litigator, but I'm now in the construction field. I'm an in-house lawyer, head of legal in a private company that is infrastructure, which they are building the rail in the UAE. So this is the company that I'm with right now.
All right, thank you so much for coming in. Really appreciate you and appreciate your effort, and we're happy that Africans are actually making waves in the field of alternative dispute resolution. Please, is there any other mentor in the house that has not spoken? Is there any mentor in the house that has not spoken? Or is there any of our invited guests? Okay. So if there are nobody and all have spoken, I will just give a closing remark and make some little observations. Now, in the course of the mentorship, when we took arbitration and careers in arbitration, we were able to give you a highlight. Just as you know, this is a mentorship program, just to give you a heads up for those of you who wants to go into arbitration and you're trying to find a career in arbitration or in ADR, mediation or arbitration. So the mentorship was a combination of mediation, arbitration, and some aspects of negotiation. Now, when we did arbitration and career and arbitration, I knew that I took time to explain to you some of the things that are expected of you. Now, you see, when some of you came and started the meeting, if you are building upon a foundation, you should let us know that you have had your preliminary meetings. And I've told you earlier that when you have your preliminary meetings, in the preliminary meeting, you are going to be taking a lot of decisions. You are going to be making a lot of appointment of the secretary or the registrar, agreement as to the fee of the arbitrator, the venue, the language, the rules, the seat of the arbitration, if it is not clearly stated in your arbitration agreement. These are some of the things that you will clearly decide on. Now, you also adopt the processes. Are you going to go for a document-only arbitration, or you are going to go for a full-blown arbitration where you are going to be having a hearing just like what we have? So if you have done all of these things, because this is the practical, we are expected that, at the inception of this thing, you introduce the parties. We have the arbitrator, we have registrar, we have the parties, we have representative as per councils. You introduce them, so they have their own rules, their own rules. Each person has his own rules. So if you appoint a secretary, the secretary from the day of your preliminary meeting and possibly the order of direction that has been issued by the arbitrator, before you came for the hearing proper, you must have confirmed are all the issues or the instruction or the order issued by the arbitrator in like the first order of direction, have they been complied with? If there are fees to be paid, have they been paid? If there are processes to be filed, have they been filed? Have they been exchanged? Is everything okay and all right? So instead of you to go straight to the arguments, like the closing remark, the conclusion after hearing, group 2, the second group that presented, went straight to closing remarks or closing arguments or final addresses, like lawyers will say, which is wonderful. I enjoyed the exchange of this, and where you see we are trying to help you build some sense of understanding in arbitration, in ADR generally. So it's not an intensive training, it's not a certification training, it's just a mentorship, so that at the end of it, you have an idea what ADR is, what mediation is, what are the different branches or the opportunities that are there. Arbitration, what are some of the careers that you can go into? You will not be a novice. You can actually make an informed decision, and then you have a little bit of the practical knowledge of what it entails. So when you are coming into the arbitration at the commencement, you come, it's not a, it's a little bit formal than mediation, than mediation. So when you have the sittings, you help us to understand this is the mediator, we have the registrar, and then you have the parties on both sides. So you take note of that. And so you are going to comment, the arbitration session is more or less like that of court's procedure. So this is something that you should take note. It's just like that. So first, I saw that some of them were adopting the processes. If you want to go into hearing, so it means that you have a party. You have filed your processes. You should have the witness for the party there present in the at the arbitration proceeding, so that the person can adopt his processes. If it is a witness for any of the parties, is going to be sworn in either by the arbitrator himself or the registrar is going to be sworn. He's going to be making his adopting the documents he has made, under oath. So if your processes were not made under oath, you file them, the arbitrator or the witness is going to be sworn by the arbitrator or the registrar, so that what he's saying is going to, he should be aware that he's making his evidence or testimony under oath. If you have already made arrangements, you have made your processes and the documents you are going to be relied upon, of course, just to adopt, then you give the opportunity for the opposing counsel to ask questions, and do a cross-examination. So we were expected to see too much detail, but at least there's steps, step by step. So at the commencement, you should help us to understand that yes, you have had a preliminary meeting. There was an order of direction issued by this thing, and those has been complied with, and then this day was slated, for the hearing of the matter. I wouldn't expect that it is the arbitrator that will now be reading out this case is between this and this and that. The purpose of appointing a registrar is because at the commencement of the procedure, at the first preliminary meeting, when you appoint the arbitrator and the party that appoint the registrar or the secretary, and the parties accepted, he starts his work. So he's going to take the recordings of the procedures of the proceedings. He will take the recordings, both handwritten or recorded, and then at the close of it, he's supposed to transcribe or make available, all that transpired, in form of record of proceedings, and send it to the party. So we try as much as possible to cut the connection between the parties and the arbitrator so that the arbitrator can concentrate on what he is supposed to be doing and allow the registry to interact with the parties. So if there are notices of meeting that needs to be filed and served, nobody has brought to attention that yes, all the parties were served. So the arbitrator at commencement, you need to find out from the registrar, have the parties been served? One of the parties just informed us that okay, the lawyer says she's representing Mr. Musa, is not going to be around, and all of those things. We don't know whether he was on notice or he was not on notice. Counsel represented. Of course, you can do that, but we are trying to help you understand the basics. Some of these little things, it may not make meaning until you go into formal trainings and you have opportunity to do the real arbitration, and then you begin to see that, oh, so I have done this, I have done that. Oh, I knew this, so this is what this is called, and all of those things. You see that the pieces of what you have learned here and there will now be making meaning to you. So at the hearing, we want to see that the witness comes, adopts his processes, and then if there are documents that have been referred to, you highlight them. Yes, in paragraph this and this and this, yes, these documents we have mentioned, they are now before the arbitrator, so questions can be made, cross-examination questions can be made based on the evidence and then the documents that were tendered. Now, at the preliminary meeting, you must have agreed whether there will be need for you to have an expert witness or not. So, all of those things are things that you would have done in the preliminary meeting, and then when you come, you want to go into hearing. Now, once there is cross-examination, at the close of cross-examination, you hand over to the, you have the claimants, and then you have the respondent. So the claimant made his own, presents his own case. Then the respondent is also given opportunity, adopts his or her processes, and is going to be cross-examined. When you finish your cross-examination, in the course of it, I remember I told you that because it is a private way of resolving disputes, it looks more like a court system, but a private way of resolving it. The rules of evidence, like lawyers that will be making objections here and there, does not apply. It does not apply. So what you do is that, and in your preliminary meeting, you must have agreed whether the parties are going to be making oral submission at the close of hearing, or they are going to do a written submission. So those things are things that you should sort out during the preliminary meeting before the order of direction will be issued by the arbitrator. So at the close of it, if you agree that the parties are going to be making presentation, are going to be making oral evidence on this thing, oral submission, your oral address. So what you do in your oral address is simple. You have presented, they have asked questions, they have asked, they have cross-examined the parties and all of those things. You summarize your evidence. What you do is just like what lawyers do in written address. They say no matter how wonderful your written address, it cannot take the place of evidence. So, but what you do is you highlight important things that you want the arbitrator to avoid his mind to, while writing his arbitration award. So you just highlight important things, okay, on this issue, whether there was a contract or not, you can raise an issue and point out, okay, so document supports this. If there are cases you need to cite, you cite it, and all of those things. Then issue number 2, is this person supposed to be entitled to a compensation, and all of those things. You do your argument, you make reference to documents, and just highlight important things that the person is going to. Then you close your submission. The other person also does it for his own party, and once that is done, that's the close of evidence. So once you confirm that everything is ready, everything has been paid, the fees has been paid. Remember, it is both parties that pays the fee. When you confirm that your fees have been settled, everything has been settled, more especially if it is an ad hoc arbitration. Institutional arbitration, if you are doing an arbitration under Settlement House Area Training Institute, for example, you may have its own rules, it may have its own scale of charges, for services. So those things will be taken care of. So before you commence, maybe you must have paid, and then, there are mechanisms and officers that will ensure that one thing or the other has been done in collaboration with the registrar or the secretary of the tribunal. But if it is ad hoc, it means that you have a secretary, you are going to make your arrangements with your secretary and go ahead to do whatever you need to do. So you must ensure that things that needs to be done should be done, especially your payment. Don't, after you conclude and you publish your award, then later on you start going after the parties, and suing the parties to recover your fee as an arbitrator. So this is something that you should avoid, So if you are doing an ad hoc arbitration, please take note. So that's very, very important. So at the close of it, you are going to adjourn the matter for an award. It seems that, all of you presented a picture that, your award was already written before the conclusion of the of the arbitration proceedings. I cannot see anybody's face. Everybody is offline. I cannot see anybody. I don't know whether I'm just talking to myself. If I'm talking to somebody, please, can you give me a thumbs up? All right. So you see, now all of you presented a picture that your award is already ready and written already. At the close of it, you didn't even say, okay, the award is going to be. When you are doing something like, we want to see it practical, because if you do it this way, another person watching you, for example, maybe following online, he will think that this is how it happens. You don't deliver award immediately you close your arbitration, so you have to adjourn. You have to adjourn to write. You can take 1 day or 1 week or 2 weeks or 6 months, depending on the complexity of the matter. You don't just finish your closing remark immediately, say you are. So you can say at the close of this thing, okay, we are going to register, confirm, have they paid all the necessary things, is everything all right, all of those things, say yes. What about the record of the proceedings? The registrar needs to compile the record, whether it is video or audio that has been recorded, and then you will compile the record and make it into writing, forward it to the parties, each of the parties, and forward it to you as an arbitrator. And you are going to use those information to write your award. And then you are publishing your award immediately, at the conclusion of oral, at the close of evidence. You just publish the award and then read it to them. Now, it may not be like it used to be in court. When they say you are publishing an award, it could just be that you have sent the awards to the parties. That is, you have published your award. It may not necessarily be parties coming and sitting and then you read it out the way they used to read judgment in court. It may not necessarily be like that. But it's not as though when it comes and you read it out is something bad, So, but you need to take note of it so that when somebody is following you will not be thinking that this is how they used to do. Immediately you finish your submission and you close your evidence, you just deliver award as though this is the format. No, you should help the person understand that, okay, when you close evidence, you take a date to deliver judgment. If you take the date and say, let's reconvene on so day, and you tell us that, okay, now that we are back, we are going to read out our award, or we are publishing the award, or okay, awards after 2 weeks will be sent to the respective parties. That is how it is. If you want us to know the content of the award, then you can now say, okay, you come by, you read the award for us to understand. So that is one the important thing you need to do. You need to understand. Then the content of the award. In your award, you should have the summary. Have the summary of the proceedings, the facts. Okay, this is the summary of the fact. This thing is an employment relationship between party this and this. Just a summary of what transpired. The claims of the parties are this and this and this. You should have a summary. Okay, this thing was conducted in English language. Yes. This thing was on the seat of the arbitration was Nigeria or whatsoever. You stated there. The venue where this arbitration took place, you stated there. All these important details, you stated there. The seat, the venue, that's the seat of the arbitration, that has to do with the applicable law, and then the physical location where the arbitration took place. We have taken time to explain the differences between the seat and the place of arbitration in the course of the mentorship. So I believe that you understand that, so you will state those things briefly, and then you are going to do your analysis. Party A has presented, this is the evidence presented by party A, this is the evidence presented by party B. You make them, what is your analysis? What are the issues you are drawing for your own determination? Okay, I've drawn these issues from this thing. Okay, is this person liable for the claim? Is the plaintiff possibly responsible, or should he be liable, or has the plaintiff proved his case? Depending on what you want to form, then you use those evidence that has been presented. Okay, party A presented this and this, which established the fact that yes, there is a contractual relationship between them, and then this person has quit his job, he has resumed his duty and responsibility, though it was clear that it is they did not he did not physically take up any responsibility, but this was the agreement based on so exhibit and so exhibit. Information will be sent to him, and he has made effort. He has been reaching out to get information as to what work he needs to do, but none was sent to him. But you will now begin to arrive at your conclusion. It is clear that this one is an employee of that organization. He has an employment letter. His salary is so amount of money, and he has worked for so period of time, and then cumulatively his salary is supposed to be so amount of money. That's if you are going to give an award in favor of the claimant. And then you can say, okay, the computation of the salary amounts to, let's say, 2 million naira, and then for depriving him the opportunity of working and earning and all the sufferings, you are awarding so damages, if possible, to be paid within so period of time, and then interest. Now, when it comes to interest, you need to be careful, because if you are in an Islamic dominated area, you need to understand the practice in that area. They don't work with interest. Interest does not apply. So you should know, when you are giving an award and you want to award interest, you should know whether that is applicable within the jurisdiction and the seat where you are operating. That is very, very important. So when you have summarized this thing, you should give your reason. Why do you agree with this person? You should give a reason why you are giving your decision in favor of so person. You can decide to say, okay, yes, I've agreed he should be paid his 4-month salary, but I do not agree that he should be paid his allowances. So your reason could be, since he's an employee, he's entitled to his salaries. And since he has made effort to look for employment or ask for work, and it has not been given to him, he is entitled to his salary. As to the issue of damages, by the way, that time is during coronavirus, and so there are no work is available
for him to do, and he has not actually carried out any work. Since I have agreed that he's responsible, he ought to be paid his salary. But the issue of damages, just for the purpose of fairness and equity, I don't believe that he's entitled to damages, because he is already giving his salary and all of those things. So you state the reason why you feel this person is entitled and the other person is not entitled. You highlight it and state it there for them as your reason why your award is going towards this particular direction. And remember to date your award. Remember to sign your award. If it is a panel, ensure that all the parties, the panel members, sign. The chairman of the tribunal, signs. The members, the two members also sign. But in a situation where, for example, one of the arbitrators decide not to sign for any of the reason, maybe he's dissenting or does not agree, two of the arbitrators, when they sign, that serves the purpose. So you must ensure that arbitration is signed. The award is signed by the arbitrators. If it is a single arbitrator or a sole arbitrator, ensure that he signs. And once that is done, you know that your arbitration award is watertight, because lawyers will be looking for excuses or the reasons why they should go and set your award aside, due to one thing or the other. The principle of that's the issue of ethics is very, very important for you to maintain, so that you will not, in the course of your arbitration, be having one kind of relationship or the other. By the way, you must have declared at the inception whether you have any interest or connection with any of the parties, whether you're accepting, and you need to disclose to the parties. If the parties say yes, no problem, you can go ahead, fine. If not, you should get yourself out of the proceedings, let them get another person. Anything that is going to temper on your impartiality, your neutrality in the matter and all of those things, you don't play or joke with them. So I think this is what I can say, except if we have questions. If there is any question, we have some of our mentors here with us, and they can help us answer some of the question. I can see Geoffrey is still here with us, and Baratu is here with us. Adams is still here with us. Believe that Isaac is here with us. So do we have any question?
For the mentees, please let's ask questions. We can take a few questions if you are able to. So please, like we normally do, indicate by raise of hand or send your questions into the chat box. That's if we do have questions.
All right. So in the absence of any question, I want to officially congratulate all of you for making it all the way to this point. Dennis, I think this is the final class for the practicals, except for the joint class for all mentees, right?
Yes, it is.
All right. So I want to congratulate all of you. Okay, what seat of arbitration? Okay, we have a question here. Dennis, can you read that question for us?
Okay, the question is, I think it's Emanuela Adebayo is asking, I want to know what the seat of arbitration will be if it is done online.
Mr. Jeffrey, will you want to answer that question?
That's a very interesting question. Who has asked the question? Can I get the name, please?
Emanuela Adebayo, Mrs. Emanuela Adebayo.
Okay,
Yes,
so Emanuela, that's a very interesting question, and I'll tell you what, first of all, why you have asked that question, and then I'll give you the answer. So you have asked that question because when you hear seat, you think of a physical seat, or you perceive a seat in the form of where we shall be sitting. So it will either be a physical place or at least a room, and yet in regarding arbitration, that's not how you should understand a seat. This is how you understand a seat in arbitration. A seat of arbitration is the jurisdictional seat, is the jurisdictional position of the arbitration. What does that mean? The court that is going to guide the proceedings. So think of it this way. Litigation and arbitration are cousins. I like calling them cousins because they're not brothers, but they are related. So every time during the arbitration process, there is a court which guides the process. Now, that seat is the guiding seat of the arbitration. When we are going to enforce, what courts are we going to go to? When we are going to have an arbitration interim granted, what court, what laws, what rules are we going to be governed by? So think of it as the cousin to the arbitration that they move together with, that in case I need an interim, I go and my cousin gives me. In case I need to summon a witness, I can go. So all the powers that you can't exercise within arbitration, that extra strength that you need from that court, I hope I'm painting pictures while explaining. That is the seat of arbitration. I hope you've understood, Emanuela.
Emanuela. Okay, I think she sent that message on maybe she's not in a position to, but well understood. What are the laws that are applicable? What laws are you going to apply? You know where? So just take note of that. It's not the physical seat. No, that's why we said a place. When you talk of seat, the way layman understands it, is referring to the place. So that's why we took time to distinguish between the seat of arbitration and the place of arbitration. The seat of arbitration can be in Nigeria, but the place of arbitration can be in London. But the applicable laws that you are using is so, but you go for the seat where is conversant and arbitration flows and there are conducive environment for arbitration. Don't just go and pick any place or just pick anything. So thank you very much. Is there any other question? Okay. If there are no questions, let me just use this opportunity and medium to officially appreciate all of you for creating time to be part of this mentorship. We started this mentorship about this is the 5th week, of this mentorship, and some of you have been consistent in attending your trainings, your meetings, and your presentations, in each of those times that the mentorship is coming up. I will really, on behalf of myself and the Institute, Settlement House ADR Training Institute, I want to thank you for the privilege of allowing us to be able to share our knowledge, our understanding with you, to some extent. We believe that some of the knowledge and understandings you've gathered in the course of this mentorship will be valuable to you, and that for some of you who want to chart a career in an alternative dispute resolution, this will be a body of knowledge that will guide you to make informed decision, as to even which part of the ADR should you go, whether it is mediation or arbitration or the combination of two, or a particular, like some of the mentors here said that they are into construction arbitration. You can see this will give you the opportunity. Thank you very much. Remember, we have made this knowledge and this mentorship to you, available to you free of charge. The only thing you can do for us is to ensure that you utilize the knowledge and the skills that you have acquired here. And then we said that when you are making postings as to some of the things you have learned for each of the weeks, if you have not done for each of those weeks, please go back and do it from the beginning to the end. We want to get to hear what you have learned on your social media for each of the sessions you have attended, what you have learned. Please ensure that you tag your mentors who were present, ensure that you tag JIIPCC, the co-organizers of this mentorship. Ensure that you tap Shati, Settlement House Area Training Institute, and all the mentors, tag them so that it will be interesting. When we see your comments on Facebook, on LinkedIn, we are very happy that at least you are getting something from what you are learning, and then we'll be able to either share, like, comment, and then repost where possible. So please do that. Meanwhile, I've also told you that Settlement House is having its certification training in mediation for those of you who are interested. The training is coming up between 16th and between 14th to 16th of this October. So for those of you who have passed the mentorship and you have finished up conclusively, you are going to be having some kind of concession when it comes to trainings. We will soon begin our certification training in arbitration. We have been doing a lot of certification trainings in mediation. Those of you who want to take up certification trainings, please don't hesitate to reach out to us, that you want to. And then when we know that you are part of our mentees, you are going to have a lot of concession, and we can see how we will make that vision of yours become a reality. So thank you so much. Thank you so much for all your efforts. Ensure that you share what you have learned on your social media handles, your WhatsApp. Also, instead of sharing pictures, ensure that you share some of the things that you have learned in the course of this. So I want to say thank you. And let me use this opportunity to also appreciate all our mentors. Mr. Isaac, all the way from Ghana, has been present from day one till today. Has been consistent. Our other mentors, they have been coming in, they have availed their time, their resources, despite their busy schedules, to be with us in the course of this mentorship. I want to say a special thank you to all of this. I pray that, you will reap the fruit of your labor. You will reap the investment you have made on these young ones, and tomorrow they can refer to you as mentors. Oh, I'm a mentee to so person, I'm mentee to so person, and it will be a great one. It will be a very wonderful one. So thank you so much for the mentors. We look forward to seeing you in our next mentorship when it comes. And for the mentees, please ensure that you conclude the session appropriately, and so that you can earn your certificate. That certificate is your gateway to other opportunities with us. Thank you so much. Thank you. Over to you, Mr. Dennis. I don't know whether anyone has a comment or something to say at this juncture, but over to you, Mr. Dennis.
All right. Thank you so much, Mr. Nyacham, for your guidance and your support throughout the course of the program. Throughout the course of this program, so far, Assessment House ADR Training Institute has helped us do due justice to the 5 weeks that we have had to deal with mediations and with alternative dispute resolution as a whole. Right. For the mentees, the program has not officially ended. You still have a week or two left in the program. So please, let's pay attention to what will be happening within your group. The dynamics of classes will be changing come next week. So please pay attention to all that. So once again, Mr. Nelcham has said it all, and I don't want to spend so much time repeating everything that has been said. But I want to thank Mr. Nelcham, Settlement House ADR Training Institute, and also to all the mentors who show week in and week out to help do due justice to alternative dispute resolution. We sincerely do appreciate you all. So just before we go, like it's in our practice, we'll just like to quickly take our last picture officially within the AGR class, right? So please, if you're in a position to turn on your video, please kindly do that. Let's take a quick picture. Thank you so much, Mr. Babajide. Can we have more mentees turn on their videos? Officially, this is technically the last picture for the ADR class. All right, thank you. Okay, I can see we're having quite a number of people turn on their videos, so I'll just give us a minute to quickly do that so that we can capture everything at once. Okay, just 1 more minute. I'll be doing that shortly. All right, we are done with that. Thank you everyone once again. Please do enjoy the rest of your evening, wherever you may be. To our guest mentors or to the guest mentors that came on board, we sincerely do appreciate your presence here with us in class. Thank you, Mr. Isaac. You know, it was really nice having you throughout the course from week 1 to week 5. Thank you so much, Ms. Baratu, also for your time and your shared knowledge in each of the sessions that you were present. To also the other mentors that were present at one point or the other, we say a very big thank you. Good night, everyone, and God bless.
Good night, and thanks for having us.